5 seconds to go. Start. Contention of Muhammad Arif Khan, learned senior advocate, assisted by Muhammad Aslam Khan, advocate for the petitioner, was that the will dated 4th July 1991, executed by Hassan in favor of the petitioner and registered as per law, was duly proved by examination of one of the attesting witnesses, but the same has been disbelieved by the courts below only on the ground it excluded the natural legal heirs, and also that there were certain discrepancies in the will, such as the last page appeared to have been added subsequently, containing the details of the holdings of Hassan, whereas, according to him, such details were mentioned on the first page of the will itself. In support of his contention, Shree Khan relied upon various decisions which shall be referred later while discussing the merits of the case. He also contended that one of the reasons which weighed heavily with the consolidation courts was that the will was executed at a time when the testator did not have the right to transfer his holding, whereas, according to him, firstly, will is not a transfer but a mode of succession. Secondly, it is well settled that will being effective on the death of the testator, if by then he had acquired transferable rights over the land so to be bequeathed, then the will could not be held to be invalid merely because at the time of its execution the testator did not have such rights as his rights over the land in question, as on the date of death had to be seen. In this regard, he relied upon various decisions of this court which shall be referred in the later part of the judgment. Lastly, Shri Khan contended that the petitioner had filed an application for getting the signatures of Hassan as appearing on the will examined by a handwriting expert, but the said application was never decided and findings were recorded as to the validity of the will, ignoring the same, which, according to him, was an apparent error committed by the courts below. On the other hand, Shri Ajmal Khan, learned counsel appearing for the contesting private respondents, the sons of Hassan, contended that Section 170 of the UPZA and LR Act barred the execution and registration of such a will by a Sardar or a Bhumidar with non-transferable rights. Therefore, in the face of such statutory bar, the will could not be read in evidence, nor could the petitioner claim any title based thereon. According to him, execution of such a will was also contrary to the object contained in sections 195 and 198 of UPZA and LR Act, which was to grant land to landless laborers for their sustenance and livelihood. Relying upon a decision of this court reported in 2006 1 JLR 789 Mansingh versus Additional Collector Muzaffarnagar and others, he contended that if transfer of land in such a way is permitted, it will defeat the very object for which the land has been granted to a landless laborer and will encourage their exploitation. According to him, the will itself could not have been registered on 4th July 1991 as it was in clear contravention of Section 170 of the Act 1950. Furthermore, learned counsel argued that apart from the will having not been proved as per law, it was also shrouded with suspicious circumstances as Hassan was an employee of the petitioner and worked at his brick kiln, where the will is said to have been executed. The petitioner, that is, the employer, was in a dominant position so as to influence Hassan. The relationship was also fiduciary. It is quite unnatural that an employee would bequeath his holding in favor of the employer who owned a brick kiln, that too when his natural legal heirs were alive, a circumstance which has not been explained by the petitioner nor has been justifiably explained in the will. In this regard, he placed reliance upon various decisions of the Supreme Court and this court, some of which will be referred in the later part of this judgment. Stop.